The Judicial Department.
Section 120. Compensation, expenses. All justices and judges shall be paid adequate compensation, which shall be fixed by the General Assembly. All compensation and necessary expenses of the Court of Justice shall be paid out of the state treasury. The compensation of a justice or judge shall not be reduced during his term. The current Constitution as originally written did not specify that the justices of the Court of Last Resort, the Court of Appeals, should be paid a salary out of the state treasury, although by statute they were. The Constitution originally provided that salaries of circuit court judges should be equal and uniform throughout the state, so far as the same shall be paid out of the state treasury. For a time the General Assembly authorized certain larger counties to supplement the salaries paid to circuit judges out of the state treasury, although eventually they were all paid the same salary out of the state treasury. The county judges, police judges, and justices of the peace were paid a salary by their respective counties and cities and also received fees earned from performing the duties of their offices. The Judicial Amendment of 1975 provides that all justices and judges shall be paid a salary from the state treasury. There have been no published judicial decisions concerning this section.
Section 121. Retirement and removal. Subject to rules of procedure to be established by the Supreme Court, and after notice and hearing, any justice of the Supreme Court or judge of the Court of Appeals, Circuit Court or District Court may be retired for disability or suspended without pay or removed for good cause by a commission composed of one judge of the Court of Appeals, selected by that court, one circuit judge and one district judge selected by a majority vote of the circuit judges and district judges, respectively. One member of the bar appointed by its governing body, and 2 persons, not members of the bench or bar, appointed by the governor. The commission shall be a state body whose members shall hold office for 4-year terms. Its action shall be subject to judicial review by the Supreme Court. The Judicial Amendment of 1975 established a Judicial Retirement and Removal Commission to compel justices and judges to retire for disability or be removed or suspended for good cause. The commission consists of one judge of the Court of Appeals, selected by that court, one circuit judge and one district judge selected by a majority vote of those 2 courts, respectively, one lawyer selected by the governing body of the bar, and 2 persons, not lawyers or judges, appointed by the governor. The commissioners have 4-year terms. The Supreme Court establishes rules of procedure for the commission and can review its actions. Under the current Constitution as originally written, the General Assembly could remove judges of the Court of Appeals for any reasonable cause on the address of 2/3 of each house of the Assembly to the governor. County court judges and justices of the peace can also be removed by indictment and conviction for misfeasance or malfeasance in office, from Section 227, and the General Assembly can remove any judge by the impeachment process, from Sections 66 to 68. The Supreme Court has ruled that a Supreme Court rule which empowered the Judicial Retirement and Removal Commission to suspend or disbar from the practice of law a judge whom it has removed exceeded the constitutional authority of Section 121, in Kentucky Bar Association v. Hardesty, 1989. It is also held that the Commission can impose lesser sanctions on judges other than retirement, removal, or suspension, in Nicholson v. Judicial Retirement and Removal Commission, 1978, and including public censure, in Dieters v. Judicial Retirement and Removal Commission, 1994. The court also ruled that a judge cannot be removed from office upon the charge of having been convicted of a felony while his or her conviction is being appealed, in Cornett v. Judicial Retirement and Removal Commission, 1981.
Section 122. Eligibility. To be eligible to serve as a justice of the Supreme Court, or a judge of the Court of Appeals, Circuit Court, or District Court, a person must be a citizen of the United States, licensed to practice law in the courts of this Commonwealth, and have been a resident of this Commonwealth and of the district from which he is elected for 2 years next preceding his taking office. In addition, to be eligible to serve as a justice of the Supreme Court or judge of the Court of Appeals or Circuit Court, a person must have been a licensed attorney for at least 8 years. No district judge shall serve who has not been a licensed attorney for at least 2 years. The current Constitution as originally written provided that members of the Court of Appeals and the Circuit Courts needed to be at least 35 years old and practicing lawyers for 8 years. County judges of quarterly courts and justices of the peace needed to be at least 35 years old but did not need to be lawyers. By statute, police court judges of first-class cities needed to have the same qualifications as circuit judges. The police court judges of other cities did not have to be lawyers and could be younger in age. The Judicial Amendment of 1975 removed the age requirement and the requirement that justices and judges have practiced as lawyers, although justices of the Supreme Court and judges of the Court of Appeals and Circuit Court must have been licensed lawyers for at least 8 years, and district court judges, licensed lawyers for at least 2 years. The Kentucky Supreme Court has held that a district judge who has been suspended from the practice of law is also under Section 122 temporarily disqualified from serving as a judge in Cornett v. Judicial Retirement and Removal Commission, 1981. The court has also ruled that the Section 122 requirement that a district judge must have resided for 2 years in the district from which he or she is elected does not imply that he or she is without authority to issue a search warrant outside the district, in Richmond v. Commonwealth, 1982.
Section 123. Prohibited activities. During his term of office, no justice of the Supreme Court or judge of the Court of Appeals, Circuit Court or District Court shall engage in the practice of law, or run for elective office other than judicial office, or hold any office in a political party or organization. By this section, the Judicial Amendment of 1975 further ensured the nonpartisan nature of the judiciary by prohibiting justices and judges from running for elective office or holding office in a political party or organization. The section also prohibits members of the judiciary from practicing law. In its original form, the Constitution did not prohibit judges from practicing law, but by statute the General Assembly prohibited judges of the Court of Appeals and the circuit courts from doing so and placed limits on county judges who were lawyers. Pursuant to its rulemaking power granted by Section 116, the Supreme Court has promulgated a code of judicial conduct that prohibits judges from engaging in certain political conduct, including making speeches for a candidate or political organization and the solicitation of political contributions. The prohibition against practicing law in Section 123 does not apply to special judges since they do not serve a term of office, but rather at the pleasure of the Chief Justice, in Regency Pheasant Run Limited v. Karam, 1993. However, in the opinion of the Attorney General, Section 123 prohibits a person from simultaneously serving as a district judge and a master commissioner, a kind of judicial assistant to a circuit judge.
Section 124. Conflicting provisions. Any remaining sections of the Constitution of Kentucky, as it existed prior to the effective date of this amendment, which are in conflict with the provisions of amended sections 110 through 125, are repealed to the extent of the conflict, but such amended sections are not intended to repeal those parts of sections 140 and 142 conferring non-judicial powers and duties upon county judges and justices of the peace. Nothing in such amended sections shall be construed to limit the powers otherwise granted by this Constitution to the county judge as the chief executive, administrative and fiscal officer of the county, or to limit the powers otherwise granted by the Constitution to the justices of the peace or county commissioners as executive, administrative and fiscal officers of a county, or of the fiscal court as a governing body of a county. Section 124 repeals all non-judicial sections that may conflict with sections 110 through 125, the essence of the Judicial Amendment of 1975, and acknowledges that the Judicial Amendment was not intended to repeal those parts of sections 140 and 142 conferring non-judicial powers and duties upon county judges and justices of the peace, or to limit their non-judicial powers or the non-judicial powers of county commissioners. The Attorney General issued an opinion in 1977 that acknowledged the effect of the Judicial Amendment on the office of county judge, namely that the office, on or after January 2, 1977, would no longer have judicial functions, but instead would have a wide range of county executive and administrative duties under the newly created title of County Judge Executive. Formerly, as judge of the Quarterly Court, the county judge heard minor civil and criminal cases, and as county judge, operated as a probate judge, probating wills and presiding over the administration of estates, and appointed and removed fiduciaries such as guardians and trustees. The county judge also served as a member of the fiscal court that administered the financial and governmental affairs of the county. A continued function of the office as revised by the Judicial Amendment. Shortly after the adoption of the Judicial Amendment, the General Assembly empowered the office of the retitled county judge executive with the authority necessary to carry out its duties as the chief administrator of county government.
Along with the amendment of 1975, a transition schedule was created. It read: as a part of this amendment and as a schedule of transitional provisions, for the purposes of this amendment. 1. The judges of the Court of Appeals in office on the effective date of this amendment shall become justices of the Supreme Court for the duration of their terms, and the election of successors shall be in accordance with those terms. 2. The circuit judges in office on the effective date of this amendment shall be continued therein for the duration of their terms. The term of office of 8 years provided in this amendment for circuit judges shall apply to the circuit judges elected at the election at which this amendment is adopted. 3. The term of office of judges of the Court of Appeals created by this amendment shall be deemed to commence as of the first Monday in January 1976. The vacancies existing on that date by virtue of no election having been held for the office in November 1975 shall be filled in accordance with Section 152 of the present Constitution and Section 118 as created by this amendment. 4. The term of office of judges of the District Court shall be deemed to commence as of the first Monday in January 1978, and judges shall be elected at the regular election next preceding that date. The District Court shall be constituted and organized as of the first Monday in January 1978. 5. The quarterly courts, county courts as judicial bodies, justices' courts and police courts in existence on the effective date of this amendment shall continue in existence until the first Monday in January 1978. For that period those courts shall continue to be governed by the present Constitution and none of the provisions of this amendment shall apply to them, except that those courts shall be deemed a part of the unified judicial system and shall be subject to the general control and rulemaking power of the Supreme Court. The terms of any police court judges which commence on the first Monday in January 1976 shall be reduced to 2 years from that date. 6. The clerk of the Court of Appeals elected at the election at which this amendment is adopted shall serve as clerk of the Supreme Court for the term for which he was elected, subject to removal by the Supreme Court for good cause. 7. Until otherwise provided by law, the statutes applicable to the present Court of Appeals and not inconsistent with this amendment shall apply to the Supreme Court. 8. All causes and proceedings pending in the present Court of Appeals on the effective date of this amendment are transferred to and shall be decided or otherwise disposed of by the Supreme Court. 9. All causes and proceedings pending in the quarterly courts, county courts as judicial bodies, justices' courts and police courts, on the first Monday in January 1978, shall then be transferred to and decided by the Circuit Court or the District Court of the area, in accordance with the respective jurisdictions prescribed for the latter courts.
Sections 125 to 139 were repealed with the amendment approved in 1975. Section 125 read at the time of repeal, Circuit Court for each county. Section 126 read at the time of repeal, Jurisdiction of Circuit Courts. Section 127 read at the time of repeal, Appeal from Circuit Court. Section 128 read at the time of repeal, Circuit Court Districts. Section 129 read at the time of repeal, Election of Circuit Judges, Term, Commissions, Removal. Section 130 read at the time of repeal, Qualifications of Circuit Judges. Section 131 read at the time of repeal, Terms of Circuit Courts. Section 132 read at the time of repeal, Additional Circuit Court Districts, Population Limits. Section 133 read at the time of repeal, Compensation of Circuit Judges. Section 134 read at the time of repeal, When districts may be changed. Section 135 read at the time of repeal, Only constitutional courts permitted. Section 136 read at the time of repeal, Special Judges of Circuit Courts. Section 137 read at the time of repeal, Circuit Court in county having population of 150,000 or more, separate district, additional judges, branches, general term, clerk, criminal cases. Section 138 read at the time of repeal, Certain counties may constitute separate district, additional judges, practice. Section 139 read at the time of repeal, Quarterly court for each county, jurisdiction, county judge to preside.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references: Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.